Are you in a position where your child's other parent has done something that's pretty awful and you're not sure whether you should attempt to modify your custody arrangement or in the alternative file a dependency and neglect action in juvenile court? Well, my name is Patrick Slaughter. I'm a family law attorney with LaFevor and Slaughter. We're a family law firm that's located in Northeast Tennessee. I'd like to offer you my opinion on that and maybe give you some guidance. There's two different legal actions that can deal with parents that commit acts that may render them to be unfit. The first of which is you can obviously file an action to modify the parenting plan that says, hey, Your Honor, we have this parenting plan in place, but these things have happened, these bad things, and because of these bad things, we think the custody arrangement between myself and my child or children's other parent needs to be changed to limit that other parent's time with the child or children. The other opportunity you have is you can file an action in juvenile court that says that, because of these actions, the child is dependent and neglected, and because the child is dependent and neglected, the other parent should not have custody of the child or have very limited custody, maybe only supervised visits, until such time as that parent can rehabilitate themselves and then move forward with a regular custody arrangement. Well, these actions on the face are mutually exclusive. You can't really file both at the same time, in theory. The reason is, if you want to file a dependency and neglect action, you have to file that in juvenile court. In Tennessee, juvenile courts have exclusive, original, and continuing jurisdiction over any dependency and neglect actions. So if you want to file a dependency and neglect action, you're going to do it in juvenile court. If you're looking to file a custody modification action, you're probably looking at doing that in either circuit or chancery court. And because the two actions aren't in the same court, they're necessarily going to have to be one or the other generally. If you're going to file a dependency and neglect action, then you would typically litigate that through juvenile court and go from there once that's concluded. Now, that doesn't mean you can't file a dependency and neglect action, go litigate that to conclusion, then turn around and file a custody modification action in one of these other courts once the dependency and neglect action has been concluded and juvenile court relinquishes jurisdiction to the other court to do that. But a lot of times that doesn't happen. And what I tell my clients is, you have to look, are you looking for a short-term solution or a long-term solution? If you're looking to do something in the immediate short term, a dependency and neglect action may be appropriate because it's not as difficult as you would think to file an action that speaks of these bad acts that would result in a juvenile court judge or magistrate removing the child from that circumstance, at least until there is some investigation and there is a trial to determine whether those things are such that the child should not continue with the current custody arrangement or that parent's custody should be limited. By contrast, when you file a modification of a custody action in one of the other courts, that's more of a permanent solution, or at least a longer term solution. It may take a little bit longer to litigate, but at the end of it, the parenting plan that is ordered by the court or agreed to by the parties will stay in place until either some event happens to warrant a change in that plan or the parties agree to. In juvenile court, however, when we're looking at the dependency and neglect action, there is a supposition that even if the other parent is found to have committed some act that constitutes dependency and neglect, not necessarily severe abuse, but dependency and neglect, there is a presupposition that once that parent has rehabilitated themselves, that if they have followed whatever actions the court has told them to do, that if they've done that, then they will be able to go back to whatever previously established parenting plan or custody order was in place prior to the filing of the dependency and neglect action. In other words, if they cure the problem that existed, once it's cured, you're going back exactly to where you were before you filed the action. And a lot of folks find that very unsatisfying for the amount of time, money, and effort they've expended in the litigation. Obviously, the juvenile court action is very emotionally charged. You also have a higher burden of proof in the juvenile action, where if you would pursue a custody modification in one of the other courts, the standard of proof isn't as high, and again, the solution may be more long-lasting than what you're looking at doing in juvenile court. So I think you have to ask yourself, is this what's going to be best for my child now? Is the situation so extreme that I need to, take immediate action to deal with this now? Or is this something that needs to be addressed and I can afford to wait a little while as we do it so I can get a more permanent solution? If all this sounds confusing, I understand. It is for a lot of other attorneys too. If you'd like, feel free to pick up the phone, give us a call. We can work through all those with you and tell you what your options are so you have a better understanding of what kind of case you want to file. In the meantime, always look out for your child's best interest, whether it's a court action or not. If there's something that has happened that you're concerned for your child's safety, do whatever you need to do to address that first, and we'll figure the legal stuff out later. So hope this helps. Take a look at your options and know what kind of actions are available to you.